In a recent video, I showed you a remark left by Niagara Regional Police Constable Todd Priddle in an internal person of interest report. Language so disturbing, it raised serious questions about bias, professionalism, and intent. Since publishing that video, I've dug deeper into the public record. What I found is not rumor, it's not speculation, it is documented in court rulings and reported by the Toronto Star. What follows is not my opinion. It is what a judge found. It is what the evidence showed. It is a part of the official history of the Niagara Regional Police Service. In December 2003, several Niagara Regional Police officers were standing roadside when a passing SUV went by. A passenger, Michael Parsons, leaned partway out of the window and shouted a taunt, "Hey, baby," toward one of the officers, Todd Priddle. The officers did not like it. What happened next became the subject of a civil trial years later. Police claimed they lawfully stopped the vehicle to investigate why Parsons was leaning out of the window. Parsons testified that he was then violently assaulted for no legitimate reason. The court heard that within moments of the stop, multiple officers arrived. Parson testified that he was pulled from the vehicle, placed in a chokehold, forced onto a roadside ditch, and repeatedly shocked with a taser, even after being restrained and handcuffed. He estimated being shocked between 10 and 15 times. Of course, the police told a very different story. They claimed Parsons was aggressive, threatening, and initiated a violent struggle. One officer described it as a full fight. Another testified he feared an object in Parsons' hand. But of course, under scrutiny, that story collapsed. Justice Harris did not mince words. He found that portions of the officer's testimony were, and I'm quoting, not forthright, evasive for self-serving reasons, and in some instances, and I'm quoting again, pure fiction. One officer testified that Parsons was threatening. Another officer, Dino Cirillo, contradicted that account, stating that Parsons had his hands up with a cell phone visible. Doesn't this sound familiar? When another officer immediately moved in and put his arm around his throat. The judge found the police had no legal reason to stop the vehicle. The judge found a chokehold was used. The judge found a taser was deployed without justification. The judge found Parsons was shocked after he was already handcuffed. And most importantly, none of those officers was threatened by him. It was, in fact, Mr. Parsons who was in danger from them. Justice Harris described the officer's conduct as troubling and offensive, saying it shocked and saddened the community. The court ultimately awarded $70,000 in damages to Parson and the driver of the vehicle. Of course, criminal charges against Parsons were never pursued. So, what happened to the officers? Nothing that resembles any real accountability. There was no internal disciplinary investigation into the assault, the false arrest, the false prosecution, or the courtroom conduct identified by the judge. The Niagara Regional Police said the officers received ethics retraining. That's it. No suspensions, no firings, no loss of pay. The financial cost of making Parsons whole didn't come from the officers involved. It came from public funds, from you. Michael Parsons later said the lawsuit was never about money. It was all about awareness. It was all about accountability. It was all about exposing the abuse of power. And this case is not an outlier. The Toronto Star's investigation found that this problem extends far beyond Niagara. Across Canada, judges have accused police officers of lying, misleading courts, fabricating evidence, often with little to no consequence. In Ontario, there is no law or policy requiring prosecutors or police services to investigate officers, even when judges explicitly find their testimony unreliable or false. When asked about this pattern, the Canadian Association of Chiefs of Police responded that courtroom misconduct should simply be reported back to the officer's own police service. What was missing was any acknowledgement of a systemic problem, any commitment to reform, any meaningful mechanism to hold officers accountable. So let's be clear about what this means. When police beat an innocent man, choke him, restrain him, shock him repeatedly, lie about it in court, and are called out by a judge, they don't lose their job. They keep their badges. They keep their authority. They keep their six-figure salaries. And it's the public that pays the bill. These are the same institutions that hold people's personal information. They know where you live. They know where you work. They know who you are. When officers with documented histories of dishonesty and violence face no real consequences, the question isn't abstract, it's personal. How safe am I? How safe are gay, queer, and trans people in Niagara? How safe is it for anyone who dares speak out? By creating this video and sharing it with you, am I now in danger? I'm continuing to push forward with my Human Rights Tribunal of Ontario complaint, and it is expensive, financially, emotionally, and physically. And if you believe that accountability matters, if you believe abuse of power should have consequences, if you believe silence only protects the powerful, please consider donating to my GoFundMe to help me cover my legal costs. If you can't donate, I understand. Share this video. Share this story. Share the facts. Because awareness is the first step towards accountability. And accountability is long overdue.